Welcome. This is for packet 5, and this is only if your spouse agrees to the divorce. And what that means is when you file your divorce paperwork, you have to serve your spouse. If you want to avoid serving your spouse and your spouse is like, you know what, I want the divorce as well, I will agree to sign whatever forms you need. This is the packet you would need, and you would have to have the spouse sign, and you would file it together with your petition. Just be aware they have to sign it. If they don't sign it and you file your paperwork, it puts a hold on your divorce until they fill out the form and send it to you. So my recommendation would be to go together with him and or her, I'm sorry, and make sure that you sign the paperwork together, because you need to file it together. Otherwise, you would have to have proof of service before the case will go forward. So we're going to go over the forms. Here we go. And this is a short checklist for all the forms. And you have all the forms that you have for your paperwork. And then you'll have these: answer, family law, financial affidavit, and social security number. And if you have children, they also have to fill out the Uniform Child Custody Jurisdiction Act. And this is the instruction. As it says, take all the forms with you when you file it. Otherwise, it will delay your case. If you think your other party will not be signing the form, or you think they will take your time, I would recommend just filing your paperwork and then trying serving them. Otherwise, again, your divorce will be delayed. This is just the instructions for your review if you need it, but I will go over the instructions with you. And so the answer that they have to fill out, if you look at the title, it says answer, waiver, and request for final judgment. I would recommend you fill out the top for him or her. If not, you can leave it blank and just let them know what the case is going to be like, because you're the petitioner and the person filling out the form is the respondent. So that person has to fill out this answer, basically saying, I agree with the divorce. Just send me the final judgment, meaning the final divorce decree. So this is where he or she will write their name, and you have to they have to also fill out other information. So they're going to do family law, financial affidavit, notice of social security number, and if there's children, Uniform Child Custody Act, which is all included. So they have to fill it and they have to get it notarized. So make sure that it's done before you file it. And remember, we went over the financial affidavit. They have to fill it out as well. So make sure, tell them to fill out the form and give it all to you or mail it all to you. So same information. They have to fill all this information out, which we went over when we were going over your packet. But these are all the forms that they would need to fill out. Notice social security number. Same thing with them. If they fill it out, they will keep it confidential once it's filed. And the last one is the Uniform Child Custody Jurisdiction Act. This is only if the children are involved in the divorce. If there's no children involved in the divorce, they don't have to fill that out. And all these forms have to be signed and notarized. So as I mentioned earlier, make sure they fill out these forms and give them to you. If they're in a different county, you could include a self-addressed envelope so they give it back to you. If you're together, I would go together with them and make sure the forms are filled out and give you the original so you could file it together. This packet is for when your spouse does not agree to the divorce. If they did agree, you would use the packet that has spouse agrees and they have an answer. If they don't agree, or you don't know whether they will agree or not, this is the packet you would use to serve your spouse. There's some forms that we went over in your initial packet 1, but we'll just go over a little bit more further with this packet. Okay, if you look at the checklist, it has the summons, process service memorandum, motion for default, and default. The summons and the process service memorandum we were discussed in your packet 1, but we'll just go over it so then you know what it looks like, and you have a second copy with this one. Again, this is only if the person that you're seeking the divorce from doesn't agree with you, and they are going to have to be served through a process server and or sheriff's office to provide notice so that they know this divorce action is going through. So the summons we went over briefly, but I'll go over it again so then you understand that what the summons is. Okay, so the summons, you're going to fill out the top as you would all the other forms, and it says summons personal service on an individual. So you have to list the person that you're seeking the divorce from, your spouse, and the address where you could serve them. Again, use an address that you know they will be there, so that if the sheriff or the process server goes, they will be there to serve. And make sure that you include this section, you include the address of the clerk, because it says a lawsuit has been filed, you have 20 calendar days to file a response, and they have to file the response with the clerk. You have to look at whichever county you're filing the divorce in, and then file clerk of court. You could look it up and get their address, their mailing address, and list their mailing address. When they file it with the clerk, they also have to send you the copy of the written response. So you're going to write your name and your address. If your address is confidential and you have a mailing address, you could write your mailing address. So when you scroll down, the next section is in Spanish, and there's also a section in Creole that you could use if they're not conversant in English. And this section you're going to leave blank because the clerk will fill it out. They will sign and stamp it or put a seal, and that makes it the official court document, which has to be served by a sheriff or process server. And the next form is the process service memorandum. This is just for information purposes to the parties that's going to serve them. If you're going to serve them with the sheriff's office, they have to have this information, same with the process server. Just beware that you have to make sure you serve with the correct sheriff's office. If you're residing in one county and the person you're seeking from a different county, you have to make sure you find the right county, because different cities have different counties. So you have to make sure you get the right county and find it. All you have to do is you could Google or call information and they will tell you. So let's say if you live in Tavares, that's Lake County. If you live in Bunnell, that's considered Volusia County. So you have to make sure you get the right county, and you have to make sure that it is served in the civil division because they do the summons. However, you could also hire a private process server. If you go to the clerk's office when you're filing your legal documents or filing your forms, you could ask the clerk, say, do you have a list of approved process servers? And they will give you a list, and you could use any of them that is listed. You could also go to each individual clerk's website, and they should have a list of process server. If not, you would have to call them and ask them, and you could use them as well. The only issue with the process server, they may cost a little bit more. Or if you're trying to serve someone that's out of state, you have to make sure you go to the right sheriff office in whichever city that they live in out of state. You might have to call them, because once you call them and get the information, you will have to mail all the forms to them, and they might charge you, and you might have to do it through a credit card and or check. So just make sure you do that. So once you fill the top part out and you make sure you got the right sheriff in whichever county and the right civil division, you're going to get the civil division or the process server. You're going to serve at least the petition for dissolution of marriage, notice of social security number, family law financial affidavit, certificate of mandatory disclosure, and if you have children, you have to serve them the Uniform Child Custody Jurisdiction Enforcement Act. So those are the documents you have to list. And you're going to do the party you want to serve, their name and their location. If you have a second address, you could use that here too. So you could do two addresses. Depending on the sheriff and or the process server, they will try and serve them multiple addresses. They might charge you extra, the process server, but you will have to list them. Also, you have to let them know if there's a weapon. And that's for the purpose of protecting the people that are serving them. And then any special instruction, if there's, they might have large dogs, or if the house is in a weird location, you could list that. And you could sign, and then what would happen is you will send the summons with this process service memorandum to the sheriff and or the process server, and they will send it. So this is what happens. Once you serve them, they have 20 days to respond. So what that means is once the party is served, the sheriff will file a form called affidavit of service or proof of service. they will send you a copy as well as file one in the court. Once that is done, you have 20 days. So the proof of service will say served May 1st at 6:30 p.m. to John Doe at this address. It will say that in the form. So they have 20 days from May 1st to file a response. So I always recommend that you wait. So it's served May 1st, put a tickler or somewhere on your calendar, May 21st or the 22nd, you call the clerk's office and say, this is my case number. I served them on this date, or there's proof of service that it was served on this date. Is there any written response? If they say no, you're going to file a motion for default, and I'll go over there in a minute. If they say yes, you don't do anything. What will happen is usually the family case manager will contact you about mediation or setting a status, because it becomes a contested action. So let's say you call and they said, nope, no one's filed a written response. You want to move the case forward, so you have to file a motion for default. What that is basically saying, because he or she did not answer, in effect, they don't care, i.e., they're agreeing with the divorce. So you're going to fill out this form, and what it does is let the court know that other party did not file an answer, so I should get a default. So you're going to fill out the top, and you're going to say the default against the respondent, and you're going to send a copy to your spouse or soon to be. You could either email them or mail them, or fax or mail, whatever is easy. You got to write their address and you sign, and your address and your name. And what will happen is, once you file that, the clerk will fill out the next form. And this is called the default, basically saying, hey, there's no answer, so you'll get a default. So once you file that motion and you get a copy of this default back, what they will do is they will either email you or mail you a copy. You got to write that. So then they send, you could get that default and ask for a final hearing. So what will happen is, usually if you're unrepresented, they have a family law case manager, or the general magistrate has a judicial assistant, or the judge's assistant will send you some information saying you're missing this, you have this. Once you get that divorce, you could contact the family case manager and say, I have a default, I would like to set a final hearing. And what would happen is the family care manager will schedule a hearing with either the general magistrate or the judge, usually general magistrate, because they have a more time on their hands. And general magistrates are what they call quasi-judicial. So because a lot of the judges have a lot on their caseload, they have a general magistrate that has just as much authority as a judge to a certain degree, and they could grant divorces or not. And they could get you in sooner, and you could get a final hearing. So once you get a final hearing, you show up to their hearing, and then they will decide whether the divorce is going to be granted. So for example, you get the default, and you get a hearing, and you go to the hearing and he doesn't show up, the court may determine whether they're going to grant the divorce right then and there. But if you go to their hearing and he or she shows up, then you might have to set a different hearing. So just be prepared for that. But getting a default will make your process go a lot faster. So those are the forms you need to file if your spouse does not agree. This packet is for people with spouses unknown location. What that means is, if you're trying to get a divorce from a person and you do not know their location, you don't have a valid address to serve them with the summons, or they're not willing to agree, or they might be somewhere else that you do not know, you don't have any relatives that know where their location is, then you will file this paperwork. What it is basically you will serve the other party by constructive service. And what that is basically say, I couldn't serve him with a summons because he had no valid address. I need to serve him a different way. And we will go over some of the form. And that is usually through posting it on a board in the courthouse, or usually by serving it through a newspaper, a notice of action through a newspaper. However, before you could do that, you have to do what's called an affidavit of diligent search, so that you know that, hey, you're letting the judge know, I tried to locate him, but I couldn't. I've gone through all these processes and I still can't find where he is. So please let me do it through constructive service. So we will go over the forms that are required. So if you look at the forms, it talks about affidavit of diligent search, notice of action for dissolution of marriage, motion for default. So you would do this form if you also try to serve him and the court, I'm sorry, and the sheriff's office or the process server couldn't find him. So let's say you did the summons, you did a process service memorandum, the sheriff went out to his location, they couldn't find him, and they will do a proof of non-service or affidavit of non-service, and you have no other alternative addresses, then you would do this form. Or if you haven't spoken to him or her in 5-6 years and you do not know where their physical location is, you don't have an address to serve them, this is the packet you would use. And we will go over the form. And it provides a short little information regarding what you would need. So the affidavit of diligent search is basically letting the court know I made a reasonable effort to try and locate him. I.e., I made a diligent search of all the public records to see if I could find an address for him or her. So what you're going to do is you're going to fill out the top that you would for normally. You're going to write your legal name. Remember I mentioned earlier what an affidavit is. I'm swearing to tell the truth, saying, Judge, I tried to find him, but I couldn't, and I swear if I'm not lying. So this is what you're saying. As it says, I have made diligent search and inquiry to discover the name, usually, and the current, usually it's just the current resident of the respondent, because you should know your spouse's name. So you're gonna look at all the lists. There's a lot on the list. However, you don't have to check every single one. As long as you check some, that's all that's required. Usually if you know their last post office, maybe they used to have a PO box and you're like, I need to find them, last known respondent and W-2, you could check each one, but you don't have to check every one of them. As long as you made what we call reasonable. You can't just say, oh, I just looked it up on Google and I couldn't find him. That's not a reasonable effort to try and search. So you could say, I looked up the DMV, I went through Department of Corrections website, or maybe the clerk's website in whichever county that he was living in, and I've asked the relatives, because I know I am still in contact with his grandma, his great grandma, but they don't have an address. That's what you could do, you know. And usually you don't have to provide proof, like you don't have to say I have all the mail back, as long as you're doing it on this affidavit is saying I swear to tell the truth. Because if for some reason the judge is like, I don't believe you, I want to show me where you sent the letter, then you have proof that you sent it. Okay, so if there was any child support that he used to pay, if he was in the military, any type of tax assessor, so you could check. You don't have to check every single one of them, but as long as you check some and any other efforts that you've made, you could say, hey, I know his next door neighbor, he told me he moved there, I tried to serve him there, I couldn't. This is the problem you have with diligent search. After you tried and you find a new address, you have to try and serve him at that new address again. And then if they don't get another mail, then you could do the diligent search. So each time you find a new address, you have to try it. But if after you tried all this, you still can't find an address, then this is what you would do. So the age of the respondent, whatever their age is, and then you could say current residence is unknown. That's what you say, okay? Because you're like, I don't know where he is. So that's what you're gonna do, all right? And you fill it out and you're saying, under penalties of perjury, I'm telling the truth. So that's all it is. So once you do that, and you have proof that you couldn't serve him, then you could do a notice of action for dissolution of marriage. And this is called constructive service. Basically, you're going to post it so that they know where they're on quote unquote notice, because you posted in a newspaper and or the clerks or some type of post board available to the public. You're letting them know I tried to serve him, I couldn't, so the court recognizes this as what we call constructive service. The only issue that you have with the constructive service is it takes time, because what you have to do is once you get the diligent search, you're like, I couldn't find the address. Now I'm going to try and do a constructive service. So what you're going to do is you're going to fill out the top, and you're going to write the person that you're seeking the divorce from, their last known address. If it's unknown, write unknown. And so it says, look, you're notified that you have to file a written notice, and you're going to write your name, your address, and when you were trying to serve, and then you're going to write the clerk's address, whichever clerk that you're filing with, and they're responsible. And then you write the action is taken. This doesn't apply because this talks about unless you have assets and liabilities that include personal property or real or personal property, then you'll do that. If there's nothing, you could write none. And so if they want, they're going to come to the clerk's office to get any type of form. And then what the clerk will do is clerk would stamp it. And so this becomes like a summons that you will have to serve. But instead of serving, you will have to post it in a newspaper. Some counties, depending on which county you're filing it, will allow you to post it in the first floor of the courthouse or the clerk's office. So you could check with the clerk that you're filing. However, if you think they won't do it, I would recommend you have to post it in the newspaper of the county that you're filing the divorce. So if you're filing in Orange County, you could do Orlando Sentinel. It does not have to be in the county that you think they reside. It has to be in the county where the divorce is filed. So make sure you find the newspaper that does that. Like I said, Orlando Sentinel, I think, does many counties in Central Florida, so you could always find it. So make sure you find the right newspaper, and you have to go contact the newspaper and go for the section for legal notices. You have to contact them and ask for legal notices and ask them, I need to post a divorce, a civil action. How much does it cost? What it is they would have to post it for 4 consecutive weeks, and they post it in the newspaper. And after 4th week, they send you a paperwork saying, hey, we posted it for 4 weeks. That's called proof of publication, to let the court know we did post it for 4 weeks. And if still that they don't file a response, then you could ask for a motion for default after 20 days from the last date it was posted. So what happens is you get a paperwork from the newspaper saying it was posted on Orlando Sentinel from May 1st, May 7th, May 14th, and May 21st. And they has a stamp from the newspaper saying that's when it was saw. So after, and then it's dated. Usually it will be dated like May 30th. So May 30th, you wait 20 days. June 20th, you call the clerk and say, hey, has anyone filed a response? No. You're going to file a motion for default saying, hey, we posted it. He or she still hasn't filed a response. So I should get a default. And default is like basically saying that because they didn't file an answer, they're in effect agreeing with the divorce. So we call it default consent. So they're agreeing by not filing anything. So you're going to file this with the clerk, fill out the top, and you don't have to mail a copy because you don't know where they're residing, but make sure you just write unknown address, and you write your name and your address and saying, hey, the respondent didn't file anything. So I'm going to send you this. And the next form is the default. So what happens is you file the motion, the clerk will file the default. You got to fill out the top and you got to fill out the bottom, right? Your name and your address. And the clerk, once they grant the default, will stamp it, date it, and send you a copy. So once you get that copy of the default, you could contact the family case manager and or the judicial assistant. You should get a list paperwork with the name of the family case manager and or the judicial assistant or the general magistrate. Then you could set a hearing for the final hearing. And if you don't hear anything, they may send you something sooner, but just make sure that you do that because you don't want your case to sit in limbo. That is the most important. And once the default is filed and then you get the hearing, what you could do is show up to the hearing. They will give you a date and time. Some judges do it by Zoom. A lot of them do it by in person now. So just make sure you're aware that they set the date that's convenient for them. So just be aware. And when you show up to the hearing, if that person, your spouse, doesn't show up or the respondent doesn't show up, the judge may grant you the divorce right there. If your spouse or respondent shows up, that means they got notice. So if he shows up, the court may set it for another hearing. It all depends on what happens. If they set it for another hearing, you can't do anything and just follow the process that they do. However, if he or she doesn't show up and the court grants you the divorce, you're just waiting for the final dissolution paperwork.